Hi everyone. Today's topic is evolution of competition law in India. So, evolution of competition law in India. After the economic reforms in 1991, there had been a subsequent change in the economic scenario, which the effects of liberalization, privatization and globalization, which impelled the need for new competition law in India. So, LPG, we shortly say it as LPG, that is liberalization, privatization and globalization, led to the economic reforms in 1991, which led to the need of a new competition law in India. So India accepted and agreed to two important agreements of the WTO, namely the GATT and the TRIPS agreement, General Agreement on Tariffs and Trade and Trade Related Acts of Intellectual Properties. So General Agreements on Tariffs and Trade is GATT and Trade Related Aspects of Intellectual Property is TRIPS. So this led to the entry of multinational companies to enter into Indian market, which made the MRTP Act less effective. So the Competition Act 2002 replaced the Monopolies and Restrictive Trade Practices Act of 1969, as the same had become obsolete on account of international economic developments relating more particularly to competition laws, and the need was felt to focus on competition in the market in India. So the central government, to serve the need, set up a high-level committee on competition policies and law, which was chaired by SVS Raghavan in October 1999, to prepare a report recommending modifications to the MRTP Act of 1969. So the report was concluded in May 2000, and this ultimately led to the repeal of the Act, and a new Act, namely the Competition Act, came into existence. The Competition Act of 2002 came into existence. So one of the essential elements of Competition Act of 2002 was establishment of the Competition Commission in India. The CCI was established under Section 7 of the Competition Act of 2002. So what is the objective of the Act? Objective of the Act: prevent practices having adverse effect on competition, promote and sustain competition in markets, and protect interest of consumers, and ensure freedom of trade carried on by other participants. What is the objective of the Act? So prevent practices having adverse effect on competition. So any appreciable adverse effect on competition would be prevented by the Competition Commission of India, established under the Competition Act of 2002. Then promote and sustain competition in markets and protect the interest of consumers. MRTP Act did not have this protecting the interest of the consumers. The last one would be ensure freedom of trade carried on by other participants. Right. The next would be Competition Act main features. Main features of the Competition Act of 2002. The main features would be anti-competitive agreements, that is Section 3, abuse of dominant position, Section 4, merger and acquisition, that would be Section 5 and 6, and competition advocacy, Section 49. So these are all the main features of the Competition Act. So now we will be seeing about the amendments of the Competition Act of 2002. The first amendment was done in 2007. The amendment says the following, right? CCI to function as a regular for preventing and regulating anti-competitive practices in the country in accordance with the Act. So under the amendment of 2007, CCI to function as a regulator for preventing and regulating anti-competitive practices in the country in accordance with the Act. Again, in 2007 amendment, notice to be given to the CCI in case of any merger or combinations within 30 days and imposition of penalty in case of failure to give notice to the CCI was amended. Then establishment of competition appellate tribunal. So under this 2007 amendment only, there was establishment of competition appellate tribunal to be headed by a 3-member quasi-judicial body headed by a chairman who is a judge of the Supreme Court or Chief Justice of a High Court. So the Act was again further amended in 2009. The amendment provides the following, that is, transferred the cases pending with Monopolies and Restrictive Trade Practices Commission to the Competition Appellate Tribunal and National Consumer Commission. So this is the amendment done under 2009. So in today's session, we covered the evolution of competition law in India, its objective, and the amendments that came under the Competition Act of 2002, that is 2007 and 2009. So I conclude by saying that Competition Act of 2002 replaced MRTP Act of 1969, and this Competition Act suited the new economic policies of India.